So, to let you guys know what's going on, here in Madison, North Carolina, on the 21st this year, we were both attacked by the Madison Police Department. You can watch that video on the channel. It's something titled like Kidnapped Again. Through that encounter, they arrested me, and the current charges that they're still trying to pursue is resisting an officer. So the last court date we had for that, they would not let me in the court with my assistive devices. And the DA did try to get a failure to appear warrant, even though I was there trying to get in. Thankfully, the judge did not go for it at that time. And we made a disability request there in person. We also made it on the phone prior to that, and they said we had to put it in writing. So we put it in writing through an attorney to the judge, and what Mrs. Justice is going to read is the response from, I think it's Freeman, right? Judge Freeman?
Yeah, Chris Freeman.
Rockingham County, Chris Freeman, yeah, Rockingham County District Court Judge in Rockingham, North Carolina. So you're going to, hear what he had to say. So take it away.
And the letter and the...
Yeah, sure.
All right, let's see. Electronic devices, including recording devices, are prohibited in the Rockingham County Courthouse pursuant to an amendment administrative order, which order is enclosed. On July 6, 2020, this office received your request on behalf of your client to enter Rockingham County Courthouse with the following: iPhone Milestone 2 voice recorder, GoPro camera and chest harness, Bose Bluetooth headset, Aftershocks Bluetooth headset, buzz clip, optical detector, backup batteries, charging cables, backpack, white cane, ball cap, selfie stick, and click rule. This office is treating this as a request for a reasonable accommodation under the Americans with Disabilities Act. After reviewing the request, this office is unable to grant permission for your client to use all the listed devices inside the courthouse. Recording devices such as cameras, cell phones, etc., are not allowed inside the courthouse. To allow such accommodations inside the courthouse would fundamentally alter the nature of the court's proceedings. The following requested devices will be allowed: buzz clip optical detector, backup batteries, charging cables, backpack, white cane, ball cap, and click rule. All other requested devices are denied. Your client is subject to being held in direct contempt, criminal contempt, if found to have recorded anything inside the courthouse, audio and or visual, and or if found to have shared, downloaded any recording, audio and or visual on any social media platform, or allowed anyone else to do the same. A copy of this letter and the related order will be provided to the Rockingham County ADA Coordinator, Rockingham County District Attorney's Office, and Rockingham County Sheriff's Department. All documents received at this office or produced by this office will be placed in the clerk's file at the Rockingham County Courthouse. If you have a complaint about this office's handling of your request for reasonable accommodations, the ADA, you may file a complaint to Administrative Office of the Courts, Court Program, attention NCAOC, Disability Access Coordinator, P.O. Box 2448, Raleigh, North Carolina 27602, or verbally at 1-919-890-1200. Sincerely, District Court Judge Chris Freeman.
All right, so he's denying these. I don't think you need to read the others, just reiterating it. Yeah. Just the order specifically that just says what that letter says. That if I try to go in with my devices, specifically the phone, which I'm using right now, the headsets that I use to use my phone, and my GoPro, that they're going to hold me in contempt. So I go everywhere with those things. I use them on a daily basis, and they do more than just take notes for me via recording, which is something I need. I need to be able to take notes. If they're saying that people can't take notes in their own court proceeding, which is basically what he's saying, or blind people can't, or maybe it's just this specific blind person can't. So that's what we got from Chris Freeman, who's the district court judge there in Rockingham County, North Carolina. So yeah, it seems like a trap. It's like an ambush. They're going to hold me in contempt or failure to appear, issue a warrant for my arrest if I don't go. If I do go, and insist on equal access under the ADA. then he's saying he's going to hold me in contempt. So that's currently where we're sitting with it. I'm trying to get a hold of my attorney to discuss the legal options of what we have to do to whether we can get this guy to cease and desist his threats, his coercion and intimidation. You want to read some of that stuff from the ADA?
Yeah. Keep
All right.
talking.
So she's going to pull up the actual parts of the Americans with Disabilities Act that show you exactly how what this little district court judge is doing is a violation of federal law. It's also codified in the North Carolina general statutes. So the General Assembly, North Carolina, has a anti-discrimination act and state law. So he's violating state and federal law with his letter and his coercion, his threats and intimidation that he's attempting here by telling me that I can't access the courts with my devices. So the phone does again, like I said, does more than record. I have notes on here that I can access. I have different case law and different things on the phone that I can access, and I can't print them out and access them, right? I've got to have my device that can read to me in my headset. The headset is so that I can use it and not interrupt the court, and have some privacy while I read my notes. Just like somebody has their own notes, it's not expected that your notes are blasted for the whole court to see, no blown up on a projector or anything. That'd be the same with denying me the use of my headset, so that I can actually have privacy while listening to my notes. It also can read documents and signs and things like that. So if they're giving me documents to review, anything like that, where they want me to sign stuff without my phone, it's I'm not going to do it because I can't read it or access it. So yeah, you want to pull up. You want to address any comments first in the chat, or do you want to?
Let's see. Just a little jaded said that's like saying a deaf man can't use his hearing aids.
Yeah, precisely.
Manny Pants was like, well, what WTF are you supposed to do? It's so messed up. Trump said, go, brother, and file a federal court injunction.
Yeah, that Trump said that might be one of the legal options that we're talking about. Yeah, to jump this court and say, hey, we need somebody from a higher court to order this judge, to cease and desist his threats and intimidation, and to then, file the criminal charges against the judge to hold him responsible for his actions. Yeah.
Somebody said that wasn't a reasonable accommodation at all. That was further back. I don't remember who said it. Yeah, there's nothing reasonable about this response.
All right, so she's going to read some of the ADA for you guys, and you can find this online. There's different sources that have the ADA posted. I think we pulled this directly off the DOJ's website, like doj.gov, under the ADA. And so she's going to read some of the sections. I think that very first one talks about how they're supposed to handle requests, specifically denials. Yeah. So that very first section, this is how they're supposed to handle a request denial. And you tell me if this is how this guy handled it. Remember, he put it in writing. Okay, that's one of the things is to put it in writing. But they're also supposed to, and she's going to read it to you, the verbiage. They're supposed to specify exactly how it's a fundamental change or an undue hardship to the organization. And he doesn't. He just says it is, right? In the letter that she just read. He just makes the claim, oh, it is. It's a fundamental change, or right?
Yeah, fundamental change.
So the burden of proof, according to the ADA, is on the entity, on the judge, to prove that and explain it in his denial letter, which he clearly did not. He just said, oh, it isn't, and I guess he's used to his word being law, or whatever.
Treated as such.
Yeah, so she'll go ahead and read the actual verbiage from the ADA that you guys can find on the DOJ's website. But go ahead.
Let's see. This is on, the ADA 35.164 duties. This subpart does not require a public entity to take any action that it can demonstrate would result in a fundamental alteration in the nature of a service, program, or activity, or an undue financial and administrative burdens. In those circumstances where personnel of the public entity believe that the proposed action would fundamentally alter the service, program, or activity, or would result in undue financial and administrative burdens, a public entity has the burden of proving that the compliance with this subpart would result in such alterations or burdens. The decision that compliance would result in such alterations or burden must be made by the head of the public entity or his or her designee after considering all resources available for use in the funding and operation of the service, program, or activity, and must be accompanied by a written statement of the reasons for reaching that conclusion. If an action required to comply with this subpart would result in such an alteration or such burdens, a public entity shall take any other action that would not result in such an alteration or such burdens would be nevertheless ensure that, to the maximum extent possible, individuals with disabilities receive the benefits or services provided by the public entity.
Right, so there you go. That's straight out of the ADA. There's the burden of proof is on them. You can't just make a claim that it's a fundamental change and deny. Sorry, you only got part of that right, dude. You have to actually explain it, how it's a fundamental change. Me having my devices doesn't change anything that you do. I'm not asking them to provide any of the devices. I'm not asking them to go buy them. So there's no undue burden. There's no financial anything I'm asking for them. I'm just simply asking them to allow me to go in unblindfolded. You know, basically was essentially what it is. That doesn't change anything that they do.
Yeah,
what else you got?
Their argument was that's the rules, and somebody else in the chat was freaking out. Well, nobody's allowed to bring electronic devices in the court. They're saying that that's the rules. Okay, so down here it says a public entity shall make reasonable modifications in policies, practices, or procedures when the modifications are necessary to avoid discrimination on the basis of a disability, unless the public entity can demonstrate that making the modifications would fundamentally alter the nature of the services, programs, or activities. It reiterates what we just read, but specifically to the policies and procedures.
Right, the burden of proof is on the judge and the court to prove that them denying it or them allowing me access to my devices would fundamentally change the court, and it just simply is not the fact.
Yeah. Do you want me to
yeah, you can
go for the bold?
Go for the coercion and intimidation threat one.
One moment, please. No private or public entity shall coerce, intimidate, threaten, or interfere with any individual in the exercise or enjoyment of, or on account of his or her having exercised or enjoyed, or on account of his or her having aided or encouraged any other individual in the exercise or enjoyment of any right granted or protected by the act or this part.
Yeah. So that's out of the ADA. The North Carolina statute has something very similar, and she doesn't have to read it. But if you want, she can post it so you guys can have it. We can also put up the judge's letter, the threat itself, so you guys have access to that. So yeah, if you guys think this is not justice, if you think this is not what the quote justice system is supposed to be doing, and you want to do something about it, redress your grievances to the government, go ahead. Feel free to do that. That's Rockingham County, North Carolina, and we can probably throw up some phone numbers and emails in the description once we get this live done. And feel free. Tomorrow is Friday. They should be open for business. If you want to try to talk and figure out what's going on, or express your beliefs that this is definitely injustice, and not only injustice but criminal, what this judge is doing. It's Chris Freeman, out of the Rockingham County District Court,
North Carolina.
In North Carolina, Rockingham County, North Carolina. Yeah, so you can try to. We'll try to find his contact information for you, as well as the district attorney and the clerk of court. That way, you guys can send in whatever you want to send in, if you want to let them know that the world's watching the injustices that's happening here in Rockingham County. There's an interesting little clip that Mrs. Justice was working on the first time we were there trying to get access, where somebody from the DA refused to identify herself, and she was saying, well, I have to sign a waiver, my right to counsel. Like, she's like, I have to sign it. Like, well, and I told her, I can't sign that. I can't read it. And she's like, well, you have to go inside with the judge and discuss that, because I asked them to provide it in a digital format, and she refused. And then...
It's not like it takes that long. Literally, whatever.
So then I told her, well, I'm not waiving any rights. I'm going to retain all my rights, including my disability rights. And her response was, well, that's not exactly how it works here. So...
Sorry, everything started talking.
So that was pretty funny. But also very, very telling at what the district attorney's office thinks about civil rights here in Rockingham County, and even her disdain for the public, that was won't even willing to identify herself when she said she works at the district attorney's office, but won't say who she is, and then tells me that I have to waive my rights, and that's just how it works here. So not only that, but she's the one that said that they won't allow me in. She's the one that refused on behalf of the district attorney's office, refused to allow me access to the courts. And then somebody else from her office went around and asked the judge for a failure to appear warrant when their office is the one that prevented me from appearing before the judge. So that's what's going on in Rockingham County, North Carolina. We'll make sure that you guys get the contact information for the district attorney's office, the judge that signed the threat, intimidation, coercion letter, and the clerk of court. So that's on the 19th of August. If things don't change and this threat is still outstanding by the time that date comes around, we anticipate me showing up, acting in good faith to adjudicate the matter, and anticipate them using violence against me again, just for simply trying to have equal access in the courts. So, you want to address any comments or anything?
Weeping Willow offered some help. I was asking them to email us, which I'm commenting as Blind Justice. Sorry, guys.
Okay.
It's me. Yeah, email us insightisfree@gmail.com.
Yeah, you want to reach out. That's the best way to reach out. insightisfree@gmail.com. There's a phone number that's posted on most or all the videos. So if you'd rather text or talk on the phone, you can do that. But if you just shoot us an email, we can usually set up a phone call pretty easily. Yeah, if you're also interested in connecting more with local activism stuff here, we're just started up a Facebook group, and shoot us an email if you want in on that, and we'll give you an invite, and you can help with some of the stuff going on in North Carolina. Anything?
They're arguing.
Yeah. Okay.
I get lost sometimes.
So other things you guys can do is share the story with any kind of news media that you want, whether it be the real media like you or the mainstream media, and we'll try to get the word spread as much as we can that this is what's happening here in the court system in North Carolina. We already reached out to the state legislators and the governor and the attorney general. So we hit all three branches at the state level to let them know, hey, this is what's happening. Is there any checks and balances above the county level? We know at the county level and below, there's none. We've already brought it to their attention, and they don't care. They're not going to do anything to stop it. They are, as far as we know, in collusion and are co-conspirators and depriving rights. And so we're taking it up to the state level and finding out if they're doing anything about it, if they're interested in coming down and using some checks and balances here at the county district court. So the other, checks and balances we have is the people. Like, it's us. We have the last line of defense. So that's in the 10th Amendment, right? The last two words. It's, federal, anything that's the powers that aren't enumerated in the Constitution that are outlined for the federal government are then revert to the state government, right? The states or the people, right? Very important. It's you and me. It's us. And then you have even in the courts, right? Through trial with jury, you guys have the ability to nullify anything, jury nullification. So if there's something going on that somebody is convicted or sorry, not convicted, but they're up on charges, they have a trial for something, and you don't think that whatever they're charged with should be a law, whether it's possession of marijuana or whatever, but by the way that the law is written, by all rights, is according to the courts, the rules of the court goes, the guy should be guilty. If you don't think it should be a law, the jury can find him not guilty, just to nullify that law, to say, no, this is an unjust law, this person shouldn't have been arrested in the first place for owning a plant, right? That's the concept of jury nullification. Is, again, the last line of defense that the people have to hold the other branches of government in check, right? When the legislative branch failed and they made some nonsensical law, when the executive branch failed and you have the cops that enforce the law, when the judicial branch failed, then you have the DA pressing charges going forward, and the judge accepting the charges, not dismissing the case. Ultimately, it lies at the people, where we can say, nope, this is all nonsense. This shouldn't have been a law in the first place. Nullify, find him not guilty. So there's all kinds of ways that we can exercise checks and balances in the system, and we're trying to use all of those by going to the state entities. We went, like I said, went to all 3 branches in the state level, because at the county level and below, they were pretty dirty. So we'll find out if they're going to do anything. We did actually get to speak to some people from the different representatives' offices, and we'll follow up with them either tomorrow or next week on Monday. So yeah, any help you guys want to do, we're definitely wanting it. Got anything? Comments or anything?
Nothing. Weeping Willow shared his phone number, so there, hit it for him real quick. I think I grabbed it, but will you just email us, please?
Yeah. Yeah, if you want me to call you, just email it, insightisfree@gmail.com.
Yeah. Manny Pants UK says, every time I get my BJ live notification, my heart's in my mouth and I feel sick. Living in the UK, I feel helpless.
Appreciate it. You can do stuff from across the pond, shoot in emails or phone calls to people.
Yeah.
Definitely appreciate it.
Jump Key's awesome. Hopefully you'll get some state attention. Yeah. We need some help. Just because we called somebody doesn't mean that you can't.
Yeah, exactly. If you guys feel free to call different state reps if you want, and governor's office, the State Bureau of Investigation, the Federal Bureau of Investigation, since we're fairly certain the county sheriff isn't going to do anything to enforce the law, state law, on this judge. So the State Bureau of Investigation probably won't do it either. But
yeah. Jack O'Neill asked if guide dogs and service animals are allowed in the court.
They're supposed to be, but they're not allowing these other devices, these other assistive tools. So who knows?
Jump Key says, I'm glad your daughter doesn't look like you, Mikey.
Jump. Hey, thanks for you emailed Leon Valley, and they read your email last week. So yeah, thanks for that, cool. Dude. That was good stuff. I did put an ADA complaint in with them, and they basically said and they don't really actually know the ADA, so we're gonna follow through and file the federal one with Leon Valley. So yeah, that's an update on that. But okay. I think Texas Sheepdog 72 uploaded a video where he just cut out the part where they kicked me out of Leon Valley City Council meeting last week, where it was Assistant Chief Gonzalez put his hands on me. Go ahead. Assistant. His abbreviation is ASS, right?
Right, of course, yes.
Yeah.
Yes.
Yeah, the ASS Chief. ASS Chief Gonzalez. All right. I think we're gonna finish this up, wrap this up. You wanna end it for me?
Sure. Oh yeah, because you're not.
Yeah. Speech on. I mean, I can do it.
Oh, you got it. Since you're doing it. They like to hear your crazy.
All right. We're out. Peace and love. Stay oppressively bear. Alert. Are you sure you want to stop stream? Cancel. Button. End. Button.